This is a screenshot video for the crimes course, and we're going to first focus our attention on the concept of criminal liability for the conduct of another. So far in the course, when we've been looking at criminal liability, we've been simply looking at the actions of one person. For example, the religious leader who chopped his follower to death. But now we're going to look at situations where we have more than, if you will, one player. And our first focus is on this question: under what circumstances can one person be held criminally liable for the crime committed by another? And the answer is found in Section 20 of the Penal Law, and I think it would be a good idea if you have it in front of you. If we boiled it down, though, we can say this: one person can be criminally liable for the criminal conduct of another person if they act with the mental culpability required for the commission of the offense and either ask or intentionally assist the other person in committing the crime. I notice that in the language of Section 20, rather than ask, we see language solicit, request, command, importune. But if you consider those four words, they all share the common feature of ask, just different ways of asking someone. And the case that I've used over the years to illustrate the application of Section 20 is the one that involved the gangster John Gotti. I think this example might be a little bit dated, but let's continue to use it. So John Gotti, by all accounts, was a crime boss in New York City, and he had reached the point where he didn't have to do the dirty work. He could send out one of his underlings to do so. And one of his lieutenants was a fellow by the name of Sammy the Bull Gravano. And Gravano, according to the results of a trial, would go out and kill people because Gotti directed him to do so. And Gotti, in other words, didn't go out and he didn't pull the trigger. He wasn't present at the scene of the murders, but nevertheless he was liable for the murders because he had the necessary element of mental culpability, intent to kill, and in this case he asked or directed Gravano to do the killings. I'm going to throw in another example here. A fellow once came to me in my law practice years ago. I always like to date these so we can't hook up real identities. And he had already been convicted in federal court and was awaiting sentencing, but he was absolutely convinced that he wasn't liable for the crime of which he was convicted. And the crime that he was convicted of was arson. And he pointed out to me that on the day that the arson occurred, and by the way, the arson was a building in which his business was located. On the day that the arson occurred, he wasn't even in Buffalo. He was in Florida with a girlfriend. Well, when you looked at the facts of the case, what you found was this. The police found the person who burnt down the building, the person who went in and started the fire. But what they also found was that the fellow who was in Florida on the night the building burnt down had put in an insurance claim for the building, which he owned, and of course he had insurance in place, and his business was failing. Further, they had the testimony of the guy who actually burnt the building down, And his testimony was that the defendant, the fellow in Florida, hired him to do so. So if you put all of those facts together, it's like Gotti, the fellow in Florida, let's go back up to the boiled down definition, was criminally liable for the arson committed by the other person because he had the mental culpability required for the crime, intent to burn down the building, and he asked or hired, which is another form of asking, the person to burn the building down. So these are some examples of how Section 20 can work. I've thrown a couple of other examples in the notes that you can consider yourself. But the point is, a defendant can be guilty for criminal conduct of another person, even if the defendant hasn't dirtied his or her hands with the actual commission of the crime, if they had the necessary element and either element of mental culpability, neither asked, directed, hired, or intentionally assisted. And one of the examples I have is a person driving a getaway car, and if you look at that, you'll see that's an example where the person didn't ask, but he intentionally assisted, and he had the necessary element to commit the robbery because he was in league with the people who actually went into the place where the robbery occurred. So that's Section 20 liability. What we also have, in addition to Section 20 liability, we have something known as anticipatory offenses. And these are separate crimes in themselves. And there are 4 of them: criminal solicitation, and you can look at Section 100 of the Penal Law; criminal facilitation, you could look at Section 115 of the Penal Law; conspiracy, and there are 2 sections of the Penal Law we have to take into account, and attempt. And by the way, no one is charged with attempt. It's obviously attempted and then fill in the crime. For example, attempted murder. And what I ask you to do in my notes is, when you're considering the material, have the statutes from the Penal Law in front of you. But criminal solicitation, which is our first anticipatory offense, is going to occur when the defendant, with the intent that a crime be committed, asks another person to commit the crime. And this will be a situation where the crime, thankfully, doesn't get committed, but the defendant has nevertheless committed the crime of solicitation by asking another person to do so. And an example might be where a person, I'm thinking of a video I once saw on one of those terrible TV shows where a spouse was in a vehicle with what turns out to be an undercover police agent, but the spouse thought that the undercover police agent was a hitman, and so the spouse is offering to pay what he thought was the hitman $5,000 to kill his spouse. Obviously, the undercover agent didn't go out and kill the spouse, but the fact that the individual, with the intent that a crime be committed, asked another person to commit the crime itself was a crime, and the crime is, in this circumstance, criminal solicitation. A second anticipatory offense is criminal facilitation, and here we have really a 3-part definition. A defendant commits criminal facilitation when the defendant believes it probable that the defendant is rendering aid to another person who intends to commit a crime, and then engages in conduct which gives the other person means or opportunity to commit the crime, and significantly, the means or opportunity assists the other person in committing the crime. And the example I use is the defendant is a lab technician who possesses a certain kind of poison. He is approached by A, who offers to buy a dose of the poison for $500 so long as it's lethal enough to kill another human being. A tells the defendant during the course of the conversation about purchasing the poison that A is not getting along with their spouse. Our defendant sells the dose of poison to A for $500. A then uses the poison to kill their spouse. Well, in this case, defendant is guilty of criminal facilitation because he believed it probable that he was assisting another person who wished to engage in criminal conduct. He gave the person means or opportunity to commit the crime, in this case murder, and the person used the means and opportunity to commit the crime. What's perhaps interesting to note is the defendant here, who is guilty of criminal facilitation, may well not be guilty of the murder itself because he may not have had any intent that the person used the poison to kill a spouse. He was simply in it to make money and might not have cared one way or the other if the person actually used the poison to kill the spouse. In that case, it would be difficult to establish the intent required for murder, but it would be easy enough to prove criminal facilitation. And these anticipatory offenses typically don't carry the penalty range that the target crime does. A third anticipatory offense is conspiracy, and we have to look at two sections of the penal law to put this together. The first part is that a person is guilty of conspiracy when, with intent that conduct constituting a crime be performed, he agrees with one or more persons to engage in or cause the performance of the crime. But we need in New York State more than intent and agreement, because in section 105.20 there is the additional requirement that a person cannot be convicted of conspiracy unless one member of the agreement, it doesn't have to be the defendant, has performed an overt act in furtherance of the conspiracy. So an example I use is that you and I, hypothetically, agree to rob a liquor store and you purchase a mask for us to wear during the robbery. I am guilty of conspiracy because I, with the intent to have a crime committed, agreed with you to commit the crime, and one of us, it didn't have to be me, but one of us, in this case it was you, engaged in an overt act to further the conspiracy. Note that the overt act doesn't itself have to be a crime, because it's not a crime to go to the costume store and buy a mask. Some of the time the overt act might be a crime. For example, if we were to steal a car to protect our identities, that would be an overt act that would be a crime, but again, there's no requirement that the overt act be a crime. Our final anticipatory offense is attempt, and again, that's got to be paired with a crime, and attempted robbery or attempted murder would be examples. I noticed that the definition of attempt in the penal law is a little bit vague, because it says that when with intent to commit a crime, the defendant engages in conduct that tends to bring about the commission of the crime. And the question is, what does influence the crime, affect the commission of the crime mean? And here, what we see is that the courts have essentially agreed that tends to bring about the commission of the crime means that the conduct of the defendant has gone far enough to establish the intent. There's a case that was out of Syracuse where it was established that a person had the intent to kill B, and the person was found 200 yards from B's house with a loaded gun. Under those circumstances, there was enough evidence to show that not only did the defendant intend to commit the crime, but that he went far enough along the course of commission to establish that, and that satisfied the so-called tend to effect requirement. So this will conclude this screenshot video.